5 seconds to go. Start. The principles explained and enunciated in the case of Sharda versus State of Maharashtra 1984 for SCC 116 remain a guiding light for the courts in regard to the proof of a case based on circumstantial evidence. Therein, this court referred to the celebrated decision and deduced 5 golden principles of proving a case based on circumstantial evidence in the following terms. It is well to remember that in cases where the evidence is of a circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn should in the first instance be fully established, and all the facts so established should be consistent only with the hypothesis of the guilt of the accused. Again, the circumstances should be of a conclusive nature and tendency, and they should be such as to exclude every hypothesis but the one proposed to be proved. In other words, there must be a chain of evidence so far complete as not to leave any reasonable ground for a conclusion consistent with the innocence of the accused, and it must be such as to show that within all human probability the act must have been done by the accused. A close analysis of this decision would show that the following conditions must be fulfilled before a case against an accused can be said to be fully established. The circumstances from which the conclusion of guilt is to be drawn should be fully established. It may be noted here that this court indicated that the circumstances concerned must or should and not may be established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved, as was held by this court. Certainly, it is a primary principle that the accused must be and not merely may be guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjectures from sure conclusions. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. These 5 golden principles, if we may say so, constitute the punch-seal of the proof of a case based on circumstantial evidence. It is also pertinent to notice that in the said case of Sharda, this court also enunciated the principles for using the false explanation or false defense as an additional link to complete the chain of circumstances in the following terms. It may be necessary here to notice a very forceful argument submitted by the additional Solicitor General, relying on a decision of this court to supplement his argument that if the defense case is false, it would constitute an additional link so as to fortify the prosecution case. It will be seen that this court, while taking into account the absence of explanation or a false explanation, did hold that it will amount to be an additional link to complete the chain, but these observations must be read in the light of what this court said earlier, viz., before a false explanation can be used as additional link, the following essential conditions must be satisfied. Various links in the chain of evidence led by the prosecution have been satisfactorily proved. The said circumstances points to the guilt of the accused with reasonable definiteness, and the circumstance is in proximity to the time and situation. If these conditions are fulfilled only, then a court can use a false explanation or a false defense as an additional link to lend an assurance to the court and not otherwise. Moving on to the other applicable provisions and principles, we may usefully take note of Section 106 of the Evidence Act, casting burden of proving a fact, especially within knowledge of any person, and a few relevant decisions in regard to its operation qua an accused. Section 106 of the Evidence Act reads as under: when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. The accused was charged of the murder of his wife. There had been allegations of ill treatment of the deceased wife by the accused husband, and though the victim had been killed by strangulation, the information given to her parents as also to all in the village was that she had died on account of snake bite. After taking note of the facts of the case, this court exposited on the principles governing the assessment of circumstantial evidence, the operation of Section 106 of the Evidence Act, and the effect of want of necessary explanation or giving of false explanation by the accused inter alia in the following passages. If an offence takes place inside the privacy of a house, and in such circumstances where the assailants have all the opportunity to plan and commit the offence at the time and in circumstances of their choice, it will be extremely difficult for the prosecution to lead evidence to establish the guilt of the accused if the strict principle of circumstantial evidence as noticed above is insisted upon by the courts. Stop.